call the case, I wanted to thank the lawyers for participating in this process that's enabling us to keep the work of the Court of Appeals and the work of the citizens and the people of the state of Tennessee moving forward. Mr. Hivner and the IT people for the AOC have done a wonderful job about making the technology work, even for people such as me. But if we do have any tech problems, don't worry about it. We'll just take a pause and we'll fix it and then move on from there. Call the case, please, Mr. Hivner.
In re Rukia B et al.
We'll hear from the appellant.
Good morning, Your Honors. Robert Asbury of the Campbell County Bar, representing the appellates Nathan and Kendra Bunch in this matter. Your Honor, just a brief history of how we arrived here. This is a step-parent adoption case with a concurrent termination of parental rights. It was filed in June of 2018. I represented the father and the potentially adoptive stepmother. The history of the case was, I'm sorry, I need to reserve my 5 minute of rebuttal time, please. I'm sorry, I forgot to tell you that.
All right, Mr. Hivner already had it.
Represented the father and the adoptive stepmother. A brief history. The father and biological mother had instituted a divorce proceeding in 2014. It's uncontroverted that the biological mother unfortunately had a long history of alcohol and drug use spanning from 2014 up through July of 2018. The divorce court had limited her to supervised visits. There had been multiple litigation in the divorce court concerning whether or not she was compliant with that. In 2017, an order had gone down that allowed her to have supervised visits with either an agreed, mutual, third-party agreed person or a professional agency such as Parent Place or the Assurance Group. And from that point forward, I think the evidence is clear that she failed to make any effort to visit with the children until after this petition to terminate and step-parent adoption was pending. Of pertinence to this, I'm sorry.
No, that was, I think, I don't know where the sound was.
Okay.
No
I think that most of the testimony in this is uncontroverted. Like I said, the mother struggled for many years with alcohol and drug use. By all accounts, the father is a very good man, a good father. The mother agreed that he and stepmother had done a phenomenally good job with the children. There is no controversy that the stepmother failed to pay any child support and failed to make any effort to visit with these children for about an 18-month period. By her own admission, that she failed to seek any visitation because the divorce court did not give her overnight visitation and that she spiraled out of control. The real issue that we're dealing with, the court made findings by clear and convincing evidence that we had proven 2 grounds for termination, that we had proven abandonment for failure to visit, and that any visits that she had done were token at best, and that she had failed to pay child support. It was uncontroverted that the father waived child support arrearage in 2015 at the time of the divorce and agreed to a lesser amount in an effort to help the mother, but that she paid no support from 2015 forward. The court made those 2 findings, and then in the best interest analysis, that's where we end up today with the issues that are presented. The court determined that we had not proven best interest, made an oral opinion from the bench where he seemed to indicate that he was concerned with the then 11-year-old child's testimony. I had objected to the child being placed on the stand. We go back and read the record, there appears to be a little bit of confusion as to how that came to be, but regardless, the court put her on the stand. He was concerned with her lack of empathy for her mother. There was testimony from a therapist who had seen her for 2 years that she was consistent in asking that her stepmother adopt her. The court declined based on best interest, finding that the child appeared to lack empathy or sympathy for her mother. We think that based on the evidence, that there's clear and convincing evidence that we proved that best interest of the child would be to allow the termination and the adoption. We had the therapist, we had a child who consistently throughout her testimony maintained that she wanted to be adopted by her stepmother. And really there was no evidence to the contrary.
Let me ask you this, Mr. Asbury. We've got 2 children in this case, correct?
Yes, ma'am.
So if we find that the trial court did not go through the factors that he was supposed to on the best interest analysis, he didn't really make any findings with respect to the younger child. So is the remedy to send it back for him to make those findings, or do you think we need to just consider the record and make that decision from what we have in the record?
Your Honor, that I agree with that question. That's why I addressed it in 3 and 4 of my statements of the issues. There is nothing in this record about Aria, the younger child. The only evidence is that, and it was uncontroverted, is that she doesn't remember her mother. I mean, I think it has to, candidly, I think it has to be remanded for the factors to be applied as to both children. I guess selfishly, I would like to say I'd just like y'all to reverse it, but in reality, there is no evidence in this record that the factors in 36-1-113 were addressed by the court in regard to either child. And in fairness to both children, I think making a decision based on his assessment of one child to the exclusion of the other child is patently unfair to both children. And I don't think the court intended to do that. I think it's just the way that the case developed. But no, I don't think there's any way to adequately address this without all 9 of those factors, plus any other factors that the court wanted to address, being spelled out in writing so we can really have a good record to figure out what that thought process was. And that sort of jumps to my 2, 3, and 4 issues, but candidly, I agree with you, Your Honor.
Counsel, I mean, one thing I found interesting is that the trial courts seemed to say that it was the stepmother, or the trial court did say that it was the stepmother that was so insistent on the older child testifying. I mean, what do you say what's in the record? I mean, is the trial court right about that, or does the record show to the contrary, or what?
Your Honor, with all due respect to the trial court, I disagree with his decision or his rendering of that in the second hearing. I filed a motion for specific findings of fact in an effort to try to clear this up. And in that memorandum opinion from July, he makes those comments about how insistent the stepmother was. When you go back and read the record at trial, that is not the case. In my opinion, I objected to the child testifying on the stand, as did the GAL. Mother and her counsel demanded that it be done on the stand. The court asked the mother and father what they thought after he asked the therapist. The therapist indicated that she was opposed to it, but that the child was mature and could handle it. The stepmother agreed that if the court wanted to hear from the stand, that was fine. But with all due respect to the trial court, no, she did not insist that the child be put on the stand. She said she was comfortable with it, as I recall. Y'all have any other questions of me?
Did the trial court make any credibility determinations?
Your Honor, it's not really clear in the record to me. He says in the opinion that the father is a wonderful guy, that the stepmother clearly loves the children and is very involved with them, and that the mother was candid in acknowledging her issues in the past. He seems to say that he is concerned with the child's lack of empathy, but doesn't really say that the child appears to be telling an untruth. He references a concern that he says, I'm not saying she was coached, but she appeared to want to please her stepmother. So if I'm not sure how to how that answers your question about credibility, but that's what the court commented on.
Thank you.
Thank you all.
All right, we'll hear from the appellee.
I apologize. I think I may have had difficulty. Can you hear me now?
Yes, we can hear you fine now.
Thank you. Good morning, Your Honors. May it please the court, my name is Christy Anderson, and I represent the mother in this case, Hannah Bunch. Mr. Asbury is correct when he states that the facts are essentially uncontroverted in this case. We have a step-parent adoption. At the time of trial, the mother testified that she had been clean from any drug use or any alcohol use since June of 2018. She testified that she had appropriate housing, that she had had support system, and that everyone in her family and friends were able to assist her. The child, when it came time for the child to testify, she would have been in 2018, I believe she would have been approximately 8-9 years old. And at the time that she testified, and I take that back, Your Honors, I apologize, I believe she was older than that. She was born in 2007. But at the time of testimony, she, the therapist testified, and because the court was concerned as to whether or not the child was in a position to be able to testify. The therapist testified that, like Mr. Asbury said, she could not say whether it would affect her or not, but that the child did seem mature. At that time, the guardian ad litem was confident that she did not believe the child should testify. And the stepfather and the stepmother, when asked, the father didn't really seem to take a position. The stepmother, however, said she'll be fine, she'll do fine when the judge asked her. And the stepmother seemed insistent that the child was in a position where she would be okay with testifying before the court. That's what ultimately made the court make the decision to allow the child to testify in open court. Yes, we had requested that.
Yes. Who was pushing, if anybody, for the child to testify in court? Was it the stepmother or the mother?
At the time that the court was going to call the child, Mr. Asbury, I believe, asked that the court be able to allow the child to testify in chambers. At that time, the mother, because as the court's aware, this is a very serious issue. Termination is a very grave and final decision. We requested on behalf of the mother that the child testify in open court. We believed that she was of the age and that she would be able to testify, and we did originally request it. With that being said, the stepmother, when the court was questioning whether or not everyone thought the child would be okay to testify, the stepmother said she'll be fine. She was shaking her head and nodding that she thought the child would do just fine on the stand. And that's what ultimately led the court to make the decision to place the child on the stand at that time. Once the child was on the stand, Mr. Asbury is correct. If I may back up, we did not hear any testimony from the younger child. She was considerably younger. Any testimony that came out in the hearing with regards to that child was very limited, and it came out through testimony of other witnesses. Once the oldest child was on the stand, she testified that the child, or that she had had a significant relationship with her mother, that her and her sister both, that her mother had been the primary caregiver while she was married to her father. I'm sorry. I apologize. I thought.
No. That was just some random sound somewhere.
I apologize. And at the time, the child testified that she had had a significant relationship with her mother, had a significant relationship with extended family, that all of those things had stopped, that she had missed those things at different times, that the stepmother had consistently, along with the father, had consistently discussed the adoption with the minor child, that they regularly talked about it. The stepmother had indicated to the child that her mother was not a good person, and because of that, the child stated that she believed her mom was not a good person because her stepmother had told her that. The influential person in the case seemed to be things that the stepmother had told the minor child. The minor child testified that the stepmother and father allowed her to make the decision whether or not she wanted to talk to her mother. She had been informed that her mother had been trying to call and communicate, and it was left up to her, she said, as to whether or not she wanted to communicate at that time with her mother. The court found it concerning that the child had indicated she had a significant relationship with her mother, that they had, and there were exhibits and that are part of the trial that show the relationship, different photographs that they had, and the court found it troubling that the child went from having a significant relationship with the mother to not having any feeling at all towards the mother. The child throughout the testimony continually looked to stepmother. The court noted after I requested multiple times that the child seemed to be looking to the stepmother for guidance. And at one point when asked about it, the child said she was looking to them to try to get her timeline correct. The child consistently looked at the stepmother throughout the hearing, and the court found that troubling as well. The child had,
let me ask you this. Ultimately, the problem I see that we have in this case is with respect to the best interest analysis, the trial court did not go through all of the statutory factors. Basically, what the trial court says was, I'm troubled because the oldest child shows a lack of empathy to the mother and the maternal grandmother, and I'm troubled that the child looked to the stepmom for answers. But the court had nothing about the youngest child. So do you agree that given there were no findings with respect to the youngest child, it has to be remanded?
Your Honors, quite frankly, I think that the court did not specifically address the younger child individually. I think the court addressed the case probably as a whole with the minor children, because we did not have any testimony from the youngest child or anyone to testify with regards to the condition of the youngest child. I think that is probably the correct remedy with regards to the youngest child. That the court did not make any specific findings other than to say that he was finding it was not appropriate, that it was not in the best interest for the termination to occur. And the court mentioned the grandmother. That was something else that the court found troubling. The trial court, on 2 occasions, the paternal grandmother, the father's mother, had filed to establish a relationship with the child or the children because she claimed that the relationship had been stopped or halted. The child testified that she had had a significant relationship with that grandmother and step-grandfather, and that she loved them dearly and that she spent a lot of time with them over the years. The child further testified that at some point she decided she didn't want to see the grandmother anymore because she found out that the grandmother was communicating with her mother. And she found that out, according to the child in testimony, because her stepmother told her. Her stepmother then allowed her to make a phone call to the grandmother, the paternal grandmother, and let her know that she was not wanting to see her, that she wasn't going to have anything to do with her. The stepmother testified that, she thought she did do that she thought that was okay, that it was important for the child to be the one making those decisions. The stepmother and the father both testified that it was in the best interest of the child to have a relationship, or the children to have a relationship with their mother if she was doing well. And the testimony at the hearing was that the mother was doing well, that she was drug-free, alcohol-free, had appropriate housing.
For how long had she been clean?
At the time of the trial, I believe she testified that she was clean as of June of 2018.
And the trial was?
In 2019, I believe, Your Honors.
When? You remember?
I believe that was I want to say it was approximately a year after.
It was June, I think it was June 2018.
I believe that's correct, Your Honor.
Looks like the petition was filed in June 2018 and the trial was April 2019. So.
Yes, Your Honor. And at that time, the mother testified that she became clean in June of 2018, right before the termination was filed. She had moments where she was doing well, but she testified that she truthfully became clean at that point, a few days, I believe, prior to the termination being received by her. The mother.
Counsel, was there any other proof presented on that other than just her testimony? Did she attend any classes, attend any treatment sessions, anything?
No, Your Honor. She testified that she had been clean, and that was the only proof that was brought in at that time. She had not obtained any type of rehabilitation as far as treatment goes.
It's interesting that though, in the case, the court did find by clear and convincing evidence grounds to support the termination. He found abandonment and, yeah, he basically found abandonment for the 4 months prior to the petition being filed.
Yes, Your Honor, he did. And the court dismissed the other grounds that were remaining. The court at that, I'm sorry?
That's fine, go ahead.
The court determined that the grounds did exist. The court also, in determining that, found that the mother had not visited in the prior 4 months. The mother testified that she had regularly seen the children since the time of the divorce, had a relationship with them until such time in May of 2017. The father notified her that her visits were stopped, that he'd gotten a court order to stop her visitation. That, in fact, was not true, and in testimony, he acknowledged that that had not happened at that moment. He did thereafter file a petition to modify, and when that was ultimately heard, the court did not modify the supervised visitation, but, however, added in a factor that it could be done at a location such as Parent Place or the Assyrian Group. At that time, the mother had not been getting to visit the children. She testified that she had attempted to call and communicate with the children, but that the father would not answer the phone. She testified that she had tried to contact through the home phone and that no one would answer that phone. The child testified that she was aware at different points that the mother had been calling, but the stepmother told her that it was her decision whether or not she chose to speak with the mother, that they were leaving that to her. The mother attempted to try to set up Parent Place in January of 2019 prior to the trial in this case. And the mother testified that she did her part. However, the father did not complete any of that. He made the decision when he was contacted by Parent Place that he was not going to do that at that time. And of course, that was based on him saying that the petition for termination was pending and he didn't feel that he had to do that. The trial court found ultimately that based on all of the factors, that with the mother having rehabilitated herself, the court found that she was doing well. The court found the mother to be sincere. He found her testimony to be truthful, and he believed her when she indicated that she had been clean and that she had appropriate housing. There were photographs submitted that were an exhibit to the home that she was living in at the time. The mother was not employed at that time, but she indicated that she had support that was helping to financially support her during that time, and that she was able to provide for the children if they were allowed to be in her life. The court, I think, found most troubling the fact that the child continued to look to the stepmother and to the father throughout her testimony, but more specifically to the stepmother. And the court was troubled by the fact that the child, who had had a significant relationship with both the mother and the grandmother, no longer had any feeling for either one. She didn't love them, didn't take any position towards them at all. And that was with regards to the stepmother and the mother. The court was troubled by that. And the court stopped short of saying that he believed that the child had been coached. He did say, however, that he believed that those things were troubling, that the stepmother continually throughout the hearing looking towards the child when she was trying to answer and the child looking to her for guidance. He specifically said at the conclusion of the hearing that taking all of those things together, the totality of the circumstances, that he believed that it was not in the best interest of the children to have the rights terminated. And the child testified that she thought it would be best to have a relationship with her mother if her mother was doing well, that she would want to have a relationship with her. And the court found that also as part of its findings, that everyone indicated that if the mother was doing well, that it was in the best interest of both children to have a relationship with the mother. And the testimony had been such that she did have everything going well. We think the trial court properly looked at everything. The trial court properly decided that it was not in the best interest of the child or the minor children to have the rights terminated. And we would just ask the court to affirm that. And thank you.
Thank you. We're here for the appellate rebuttal.
Very, very briefly, Your Honors, I think it goes back to the 9 factors. The record is what it is. There is no evidence, unfortunately, that the court addressed the non-statutory factors. It seems that he based his decision solely on his perceived lack of empathy for the child and his concern that she had somehow been manipulated or coached. In her testimony, while explicitly saying that he wasn't going to say she was coached. I really think that the law is clear. We have to address these 9 factors, preferably in a written memorandum where we have a good record to try to analyze what the trial court's thought process was. And even though I think the law is clear that the trial court can base a decision on one factor, if it's overwhelming, I don't think they have to balance it out and say that it's a majority or anything like that. We do have to have an analysis of all 9 of those factors, plus any other factors that the court deemed appropriate. And unfortunately, in this record, it's simply non-existent. And I think for that reason, it needs to be remanded to address that. And again, to address the fact that we have 2 children here, and there is absolutely no evidence as to the younger child in the court's decision-making. The only evidence in the record, and it was uncontroverted, is that the younger child really has no memory of her biological mother. And to treat these children differently or make a decision for both children based on one, I think is inherently unfair to both children. Do you all have any other questions of me?
I hear none. Thanks to counsel for both sides. We appreciate your argument this morning. Mr. Hibner, if you would, please adjourn court till 1:30 this afternoon.
This honorable court is now in recess until 1:30 p.m.
Thank you.
Thank you.
Thank you.
Counsel, you may leave the meeting now.
Thank you.
Thank you. All right.
Okay.
Another breakout room invite. See you at 1:30.
Yep.
Thank you.
Kevin, are you sending the invites? Oh, there we go.
Just got it.
Sorry about that. My microphone wasn't working.
No problem.
Had another one plugged in, I think. A bunch of different things plugged into this computer.